What the court does, it's called the Yale thesis. What the court does, and I picked that up from Judge Bork, so it's not original with me. What the Yale thesis means, very simply, is this. A case appears before the court decides how it wants it to go, and then wraps the decision in constitutional language and sends it to the morons out here. See? And we say, well, we fuss a while, and we talk about it and so forth. We don't, most people, including myself, I'm not a constitutional attorney. I've just made a point of trying to understand the crisis and how it's come about, and I've had to read a lot of decisions and so forth and so on, and dissents, which are very troubling. In fact, the dissents of the justices give the people some of the very best evidence that the court is out of control. But they'll say things like, this decision by the majority is nothing more than the exercise of raw judicial power. Or that this decision has no root in the Constitution of the United States. Scalia just did that. And he wrote a blistering dissent. I mean blistering. I've read over it a couple of times. It's quite a heated dissent in the Doma case. United States versus Windsor. That was the homosexual couple. Her mate died, or whatever you want to call her, partner. Her partner died, and she had to pay $350,000 estate taxes. And she said if we had been married, it would not. I would not have been required. So the Supreme Court struck DOMA, Section 3 of the DOMA Act, Defense of Marriage Act, which Congress passed in 1996. And Justice Scalia said there was no basis in the Constitution for the decision. But what the court has done, as we'll see in a moment, what the court has done in this DOMA decision is it has opened the door to an attack by ACLU and others on the constitutional statutes in 30 states which describe law or have embodied in law constitutionally that marriage is between a man and a woman. If you read Kennedy's and his words, and this guy is incredible. He's the swing man. He took O'Connor's place. He goes with the conservatives sometimes. He goes with the liberals. In this case, he went with the 4 liberals. And so you had a 5-4 decision. A lot of 5-4 decisions come out of the Supreme Court. He decided that it was that DOMA was a denial of equality. A denial of equality. He also said that when Congress passed it, it was to him obvious that they had animus against this body of people, this group of people. Well, he said the same thing in Lawrence versus Texas, in which he struck the sodomy law of Texas and also the sodomy laws in 13 other states. So now the states can no longer enforce sodomy laws. So if you get a chance, I would very much encourage you to go to the internet and look up that decision, U.S. versus Windsor, and read Scalia's dissent in that particular case as well. It wouldn't hurt to read Kennedy, who wrote the majority opinion as well. So what this means when the Constitution no longer is the guide, when it no longer serves as the original intent, what happens is we get increasingly, or rather decreasingly, where the court is no longer guided by the rule of law. The Constitution declares in Article 6 that it is the supreme law of the land. And the judges, as you know, take an oath to uphold this law. But if original intent is abandoned, then they are no longer bound, at least in their minds, they're no longer bound. They violate their oath. They're no longer bound by the Constitution, and so they are not guided by rule of law as rooted in the principles and the meanings of the words in the Constitution itself. And so law, we have law only in the name of law as defined and determined by 9 unelected and unaccountable jurists. There's a 5th factor that has played a major role in the introduction and the advance of the constitutional crisis. Increasingly, we have constitutional theories which reject outrightly not only the original intent, but the Constitution itself. The foundational beliefs undergirding these new theories are twofold. First, that the belief that the present Constitution is no longer relevant to the needs and demands of the modern age. This goes back to Mr. Pound and his sociological law, that law should meet the ever-changing needs. Well, it can, but it's up to the people. It's up to we, the people of the states, to change the Constitution if we deem it essential or necessary to change it under Article 5. First, there's the belief then that this Constitution is no longer relevant. It is the Constitution, or rather the postulation of Bruce Ackerman. Now, he's of Yale Law and a constitutional professor. He said that the Constitution may legitimately undergo structural amendments that bypass the amendment process. And who do you think makes the changes, the amendments? The court, the justices of the Supreme Court. He also said, and I quote him, "We must transcend the framers' vision if we are to make our Constitution." Who's the we? Well, in my mind, he's talking about the constitutional lawyers, the professors, the theory makers, if you will, that we are to make our Constitution fit the needs of a modern democratic society. Such a process, not only in violation of the Constitution as the supreme law of the land, but it is also anti-democratarian. By that I mean it silences the voice of the people. It thwarts the will of the people. The court then becomes the voice. It becomes the one who tells us this is the way it's going to be. What's going to come out of DOMA? Already, by the way, Virginia, ACLU is filing a lawsuit in Virginia in federal court to overcome our constitutional amendment to marriage between a man and a woman. They're also going to file in Arkansas, and I read they're going to file in Pennsylvania if they haven't already done so. Eventually, they'll file, most likely, in the remainder of those states that have that constitutional amendment. So what is going to happen? The groundwork was laid not only in Romer versus Evans and Lawrence versus Texas, both of those decisions written by Anthony Kennedy, but now this DOMA decision has opened the window, has thrown open the door for the constitutionalizing of homosexual marriage. Once homosexuals are given the permission to marry, then other combinations will come online. And I don't know how you're going to deny them the rights either. It can be 3 men and 2 women. It can be what the Mormons sometime, or some of the Mormons have, not all, but some, polygamy. Or it could be a woman who wants to marry her son. It could be any combination you can imagine. And then they too will demand their rights and their liberties. And the chances are they'll get them under the word liberty, opened up, substantive, opened up and given that meaning that the court wishes to give it, and thus move it out of a procedural process to a substantive process, or a process that grants the rights and the liberties that the court decides. Again, the court has no authority to create rights. Mr. Hamilton said in Federal 78, the court has neither will nor force, only judgment. He also said in Federal 78 that the court has no power of resolution. It has no power to alter society. It has no power, no authority was given to the court to alter, to restructure, to redirect this nation, to alter its founding order. By what authority, I ask, does it do it? It has no such authority, because we the people have given them no such authority. They have assumed it. They've taken it for themselves. And we are paying a terrible price for it. A sixth factor contributing to the constitutional crisis established by or constituted or promoted by the Supreme Court is reliance on foreign decisions. The court is increasingly looking at what other European countries are doing in particular cases. What they're doing, for example, in homosexuality or other types of decisions. They're also looking at the international courts for formulation now of our own decisions. When Sandra Day O'Connor was still on the court, she spoke before the Georgetown Law School, the International Center they call it, and this is what she said. I quote, "In a world that is increasingly interconnected." Now, increasing numbers of our elite, so-called quote-unquote, of our elite, are globalists. They're internationalists. They're no longer nationalists. They don't think of the United States of America as just a nation. They think globally. They think internationally. Well, this mindset or this thinking, you see, is also lodged in some of the members of the Supreme Court of the United States. In a world that is increasingly interconnected, understanding international law is vitally important, she said, for today's legal scholars, lawyers, and judges. International law often plays an important role in interpreting laws in the United States. When gaps or inconsistencies exist, that is in our law, international precedents may be considered. So much for the United States Constitution, for we the people forming the United States of America. We are being governed increasingly by what other countries are doing, by decisions being made by foreign bodies. In the landmark decision of Lawrence versus Texas, Justice Kennedy wrote the majority opinion. He used a 1967 to help him form his decision that he was going to strike the sodomy law of Texas. He used the 1967 Act of the British Parliament, which decriminalized sodomy. He also used the European Convention of Human Rights and a 1981 decision by the European Court of Human Rights in overturning the sodomy law in Texas and in 13 others. Now I want you to listen carefully to what Kennedy said. Now, in Texas, two men, an officer was there to make an arrest, and he found two men engaged in homosexual activity. He arrested them because they violated Texas law. I want you to listen to what Kennedy said, and this will tell you where these people are headed, or where we're headed as to homosexuality. The right, I'm quoting him, the right the petitioners, meaning the two homosexuals, the right the petitioners seek in this case to engage in sodomy has been accepted as an integral part of human freedom in many other, are you listening, countries. Values we share with a wider civilization. Isn't that incredible? Wonder what they'll do with pedophilia. Wonder if they'll find a law for that sometime. I don't know. By the way, there's already been a meeting in Maryland within the last few years to legalize pedophilia. That sex between adults and consenting young ones is fine. As long as they consent, that's okay. Did you know that child pornography is the #1 seller in the United States of America? The #1 seller. When I was in law enforcement at the beach, I would not, because there are women present, I would not stand and go into great details. But just what I saw, and I only looked at enough of it, and I am grateful to God. I was not a Christian at the time, but I am grateful to God that it never got a hold on me. I never got into pornography. And I'm grateful now because I learned as a Christian that it's addictive. A man starts, he's satisfied at first to watch a man and a woman, and then it just goes downhill after that because it doesn't give him the same bang. So he has to find other sources of activity in order to get the same high, to get the same kick. But this stuff is, let me tell you, is straight out of hell. But the Supreme Court of the United States, one was the COPA, the Child Online Protection Act. They even struck that, giving it First Amendment protection. The Congress attempted or did pass a law, and what they were trying to do was protect children. Even if you had, and with the modern technology, and you guys, some of you guys and women understand this better than I do, because I'm reached age, I'm not into all this stuff, I'm not up on it. But there are technologies available today that you can't tell. They can use various technical means to give the children in these films to look exactly, you would think you're looking at live actual children, but they're not. And the court threw it out, First Amendment, because they said it would restrict the adults who like to watch it and struggle. No basis in the Constitution, by the way, for that.